Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about boost for maritime law and transport arbitration in Australia. In April 2007, the Australian Attorney General announced government support to boost Australia as a regional centre for maritime and transport arbitration. The Australian government announced the formation of the Australian Maritime and Transport Arbitration Commission to encourage and facilitate maritime and other transport arbitration as a preferred method of commercial dispute resolution in Australia. The move is designed not only to encourage maritime and other transport arbitration between Australian parties but also involving non-Australian parties, which is frequently the case in maritime disputes. The move has been welcomed by the maritime community generally and had been supported by prominent peak bodies such as the Maritime Law Association of Australia and New Zealand or MLA-ANZ, and the Federal Court of Australia, which currently hears most maritime-related disputes. Indeed, a recent full federal court decision in the Commandant has major ramifications for maritime arbitration. In this decision, the court overturned an anti-suit injunction originally granted by the trial judge in favor of Australian charterers. The full federal court stayed the court proceedings in favor of the arbitration provision in the relevant charter party, which provided for arbitration in London under English law. The Greek owners has pressed for the dispute to be resolved in accordance with the charter party provisions. The Australian time charterers had been keen to utilize the provisions of the Australian Trade Practices or Practices Act or 1974 involving misleading and deceptive conduct, which would not apply should the dispute be arbitrated under English law. The federal court has also been active in encouraging mediation of maritime disputes and also recently set up a procedure whereby a small cargo claims are compulsory revert to mediation before a register of the federal court. Voluntary mediation between parties or encouraged by the courts has become a popular and effective way of resolving many shipping and other transport and related disputes in Australia in the last decade. The essence of a successful mediation is that all parties need to be willing to compromise and the mediator needs to be an effective facilitator. With arbitration as with litigation in court, the tribunal will decide the dispute, which will result in there being a winner and a loser. It would be fair to say that unlike maritime mediation and litigation, maritime arbitration in Australia has struggled to obtain recognition internationally, notwithstanding the existence of helpful legislation such as the Australian International Arbitration Act 1973. The existence of the MLAENZ Maritime Arbitration rules various arbitral bodies providing the facilities for international commercial arbitration, as well as an experienced body of maritime arbitrators and also lawyers. Although there are some maritime arbitrations in Australia pursuant to standard shipping dispute resolution clauses, for the instance under some of charter parties, and widely used in bulk trades and other maritime arbitration, take place pursuant to ad hoc agreements between the parties after the emergence of a dispute. There has been until now no peak organization such as the LMAA in London controlling maritime arbitrations in the Australia. In practices, there also has been a degree of the great reticence of the parties involved in international shipping to submit their disputes to arbitration in Australia. Unhealthy dispute resolution clauses are often ignored during the negotiation of shipping contracts, and it is such as charter parties, contracts of affreightment, and bills of lading, or the latter are invariably standard forms with negotiation taking place on the small print where dispute resolution clauses appear. Australian shipper, charterers, and even shipbuilders often comment that it is difficult to persuade a non-Australian party to agree to Australian law or arbitration when they are comfortable with, say, English law and also London arbitration. Notwithstanding that Australian shipping law is similar to English shipping law, at least one prominent player in the Australian shipping industry has commented that he likes his trips to London too much to give them up to arbitrate in the Australia, even where the evidence is in Australia. The government announcement is a very good start, but the international shipping community will need be persuaded that there are benefits in submitting themselves to Australian law and arbitrations. Certainly, the savings in legal costs and the relative speed with which such arbitrations and mediations can be progressed compared to the some overseas arbitration centers should be compelling factors for the cost and time conscious shipping industry. In this context, it is interesting to note that at the same time that the Australian government and courts are encouraging a local arbitration and mediation and giving precedence to foreign law and arbitration clauses over attempt to litigate in Australia, there is a vigorous debate in London between prominent shipping and also lawyer and some of the members of the LMAA as to the benefits of the arbitration in London with its delays and cost comparing to the relative speed. So thank you for watching, and don't forget to like, comment, and subscribe.